This meeting of the Public Utility Commission of Texas will come to order to consider matters that have been duly posted with the Secretary of State for August 21st, 2026. Good morning, everyone. Thank you for being here. Commissioners, we'll take up the items on the agenda in order today. We'll hear public comment on matters not posted, and then we'll go to the contested cases where we'll hear oral argument on the transmission lines in front of us. We do need to excuse Commissioner Rhode again for today's open meeting, so I will entertain a motion to excuse Commissioner Rhode's absence from this open meeting.
So moved.
Second.
I have a motion and a second. All those in favor say aye.
Aye.
Opposed? Motion prevails. All right, Ron, since there's no consent agenda, we'll go directly to public comment. I just want to remind everyone we're going to do 3 minutes for public comment and 3 minutes for oral argument. If you speak during the public comment portion, please speak generally about the topic. And then if you are here to speak on the contested cases, please contain those comments to the specifics of those cases. We're going to adhere to 3 minutes strictly. I don't know how many people have signed up, but we want to make sure that we're sensitive to everybody's time. So we'll show you some grace to be able to finish your thought or your comment, but please do your best to adhere to that 3 minutes. Ron, has anyone signed up for public comment today?
Yes, good morning, Chairman, Commissioners. We have 2 signed in for public comment. Alex will call their names.
Perfect.
First, Judge Brandon Huckabee. Could you come up to one of the chairs on my right?
Good morning, Judge. Nice to see you again.
Good morning. Nice to see you again. Hopefully we don't see you tomorrow, right? Chairman and Commissioners, thank you for the opportunity to speak. Yesterday I spoke about process. Today I want to talk about something more fundamental, the responsibility that comes with being entrusted with power. I am blessed to serve as Erath County's judge. I know what it's like to sit on the other side of this table, to have people come before you knowing that a decision that you make may affect their property, their livelihood, or their family's future. And I've learned something from that responsibility. The greater the power government exercises, the greater our obligation should be to make certain that we exercise it fairly. There will always be deadlines. There will always be money already invested. There will always be experts telling us why something needs to move forward. There will always be lawyers explaining what government can do. But those of us entrusted with public office, there's another question. We must a piece of property, a farm their family has worked for generations, a home for children, a business that represents everything they've built. And sometimes all they have standing between themselves and the enormous power of government are the people sitting in chairs like yours and the willingness of those people to listen. That is why these positions matter. Powerful institutions will always have lawyers, experts, resources, and a voice. The measure of government is whether the individual Texan has a meaningful voice too. And I believe there's something else important about public service. Changing course when the facts demand it is not weakness. Admitting that something deserves another look is not failure. Sometimes those are the clearest demonstrations of leadership, because our responsibility isn't to defend the momentum of government. Our responsibility is the people government exists to serve. Commissioners, long after deadlines have passed and today's agenda has been forgotten, Texans, my citizens, will still have to live with decisions made in this room. I hope that every decision you make, particularly those affecting private property, you choose careful judgment over momentum, fairness over convenience, and the rights of individual Texans over the pressure simply to move forward. The power government possesses matters, but how we choose to exercise that power matters even more. Thank you.
Thank you for being here this morning.
Next, Kevin Kennedy.
Good morning, Mr. Kennedy. Like the shirt again.
I wore this for you, Chairman. So did y'all know that my name's Kevin Kennedy? And I'm from Mahomet, Texas, which is in Burnet County. And my family's got a really nice little place on a beautiful bend of the San Gabriel River. And about a little over a year ago, 14 months ago, y'all came knocking on my door. Not necessarily y'all, but the folks that you're to govern. And my wife, she told me, she said, Kevin, you need to keep this thing off our place. And you need to keep it off our neighbor's place. And that's why I'm here, because all those people sitting over there are my neighbors. And even though they may be 200 miles away, or some of them may be 400 miles away, they're my neighbors. And a week ago, I came in here and I read Travis's letter from the Alamo to y'all. And if that letter doesn't make your chest swell up with pride and your eyes well up with tears, then you might need to get yourself to the nearest hospital and see if you've got a heart beating in your chest. And I know it did, because I could see it in y'all's eyes and all across the room. And it was hard for me to get through. I probably read that letter 30 times the night before trying to get ready to do that, and I couldn't get through it. I wish I'd known Travis. He was a fine man, had to be a fine man. You know, there's something special about Texas. A lot of people have said that it's not a map or some big patch of dirt, that it's a state of mind. And I guarantee you that's a fact. And we need to protect what Texas is. I had the pleasure of being able to meet with some folks on the second floor of the Capitol on Wednesday morning. And the other landowner that was with me, John Burrow, we said there's three things that we want. We want a reliable grid, we want to protect landowners, and we want to keep Texas, Texas. And as far as we can tell, there isn't anybody that's focused clearly on those three things. And we're going to fool around and squander all three of them. And that's the reason that for the last 14 months, I've dug in just as hard and as deep as I can. And I've gone down every rabbit hole. I've peeked around every corner. I've peered under the covers. I've thrown back the curtains, and kind of like I think I said to y'all the very first time I came up here in front of y'all, I'm going to do the best I can to turn the lights on and let everybody see. And I think that we've done that. And I think that we've delivered that withering light of scrutiny. And I am pleased that we've been able to bring that to you. And I look forward to hearing y'all's resolution of that on all of these Permian Basin projects. And I appreciate what y'all do, and I appreciate you giving me the opportunity to speak. Thank you.
Yes, sir. Thank you for being here.
That concludes public comment.
All right, so that then will take us to item number 2. Ron, will you lay out item number 2, please?
Yes, sir. Item number 2 is docket number 59029. It's the application of Oncor Electric Delivery Company, LLC, to amend its certificate of convenience and necessity for the longshore switch, drill hole switch, 765 kilovolt transmission line project in Andrews, Culberson, Ector, Glasscock, Howard, Loving, Martin, Midland, Reeves, and Winkler counties. And this commission abated this matter at its June 17th, 2026 open meeting.
Thank you, Ron. So as Ron laid out the procedural history, this docket's currently abated. I think we need to end the abatement for now. That the PFD in docket 59315 has been filed. So I'd ask that we do that. I'd entertain a motion to end the abatement of this docket.
So moved. Second.
Have a motion and a second. All those in favor say aye.
Aye.
Any opposed? Motion prevails. All right, so Ron, I think at this point we also need to call up item number 3.
Yes,
So
sir.
will you please lay out item number 3, please?
Item number 3 is docket number 59315. It's the application of Oncor Electric Delivery Company, LLC, to amend its certificate of convenience and necessity for the Dinosaur Switch, Longshore Switch, 765 kilovolt transmission line project in Borden, Bosque, Brown, Callahan, Koch, Coleman, Comanche, Eastland, Erath, Glasscock, Hamilton, Hood, Howard, Jones, Mitchell, Nolan, Runnels, Shackelford, Somerville, Stevens, Sterling, and Taylor counties.
Thank you, Ron. That's a lot of counties.
Yep.
So, Commissioners, I believe we need to consolidate these two matters. These two CCN applications are part of the Permian Basin Reliability Plan. The application in Docket 59029 involves the western leg of Import Path 1, and the application in the docket for the eastern part of Path 1 is in 59315. I believe PURE requires the Commission to consolidate these CCN proceedings, but the primary issue common to both is the issue of need, so I would constrain this to just dealing with the issue of need only. Any thoughts or comments on that path forward?
I'm in agreement. I'm in agreement as well.
I'll entertain a motion to consolidate docket 59029 and 59315 for the limited purpose of considering need.
So moved.
Second.
A motion and a second. All those in favor say aye.
Aye.
Opposed? Motion prevails. All right, so we granted oral argument in this, so we'll go ahead and begin oral argument. Alex, if you want to read out the names of the folks who have signed up.
If I could have a moment, Chairman. Yes, the two dockets, 59029 and 59315, we signed up in separate queues. For the sake of administrative convenience, we'll take up the speakers for 59029, the western leg first. So could you come up to the front on the chairs to my right, the following speakers: Cowden Crossbar Ranch LP, American Stewards of Liberty, Lazy Leven Ranch,
We'll just wait for our last panelist.
and as a reminder, please state your name for the record. The mics are pretty good at picking it up, but we'll give you a reminder if we can't hear you. Go ahead.
Commissioners, can y'all hear me?
Yes, sir.
My name is Joe Will Ross. Okay. I speak slowly. I'm from West Texas. I represent Cowden Crossbar Ranch in this docket, and in 315, I represent Broken O. Was not prepared to talk anything about need. Let's talk about routing. Y'all heard me back on June 17th talk about that. So we didn't brief it. I think the need is there. But on the routing, do y'all want me to go into that at all, or is that I need to come back next week for that? Okay. Well, let me just talk about the routing real quick. In 029, it's best meets route. It's 476 that the ALJ selected. Cowden Crossbar, we will hold our nose and take that route because it is farther away from our headquarters than the link closest to their headquarters and closer to Midland. We can also support the Lazy Leven route 368 going south and our friends the Newmans. And y'all heard me speak about that last time. More importantly, on 315, let me talk about that we support Route 559. And here's why. Because my client, Broken O, land and cattle, they are on Link L2. Link L2, I believe, is the longest single link on the entire study area. It's about 26, 27, 28 miles long in a straight line from east to west. And it's 4 or 5 ranches. Used to be one big ranch, the Spade Ranch, the inventor of barbed wire. Why is it important? Why is it in a straight line? Because all the applicant did was just pick a section line and follow it straight from east to west. They didn't follow property lines. If they had done that, that line would have been a mile to 2 miles farther south. Why is Link L2 bad? Because when it crosses Highway 163, about 17 miles due north of Sterling City, between Sterling City and Colorado City, there's a windmill, a water well, a dirt tank, and a concrete tank on the Spade Ranch within feet, 10, 15 feet from the highway. They drive, they look. They admitted that they missed it. They didn't see it. L2 goes right over the dirt tank. It's 28 feet due north of the water well and the concrete tank. That's on the east side of 163 on the Spade Ranch. Immediately to the west side of 163 starts Broken O. They have a water well also. Now, that same water well and windmill and those two tanks supply water to Broken O, my client. L2 is a bad link because it takes out water. Oncor admitted that they take out any above ground structures. You can't work on a water well underneath a set of wires. Can't do it. Then you move farther west on Broken O, it goes right by my client's within 400 feet of his barn dominium where his daughter lived. They admitted that they did not count it as a habitable structure. We told them at the open meeting, we put it in our direct testimony, they still didn't amend their errata. They said it's a matter of interpretation. Well, if you can count an RV trailer or a hunting shack, you ought to be able to account for a barn dominium that's at least a 10,000 square foot footprint that you can easily see from the space station. Get a little worked up, and I'm sorry, I appreciate your consideration. We support Route 559 in the Dinosaur 315 case. Thank you.
Thank you.
Good morning. My name is Elena Fulgaris, and I'm going to talk briefly about something that occurred yesterday, and that was the PFD in Docket 59475 that came out. That PFD confirms...
Yeah, so we can't talk about a case that isn't before us in this. We have to contain everything we're talking about to this case, to these two cases.
I understand. Well, that still brings me to my point that ASL believes that the need determination should be deferred until any determination of 59475, and that will be the last time I mention that docket number, I promise. There is the possibility in the Permian Basin, which is one of the most energy-dense regions in Texas, if not the United States, for local dispatchable generation. There are projects currently in the works that are proving that now. And it is that possibility and that need determination that warrants further examination before Texas is committed to an unprecedented 765 transmission build-out. We ask that the commission further review this need determination, not only in this docket, but also in docket 59315 as well, which I understand that you have consolidated. That need determination warrants another examination. The Permian Basin Reliability Plan, where we are right now with the Permian Basin Reliability Plan, we don't dispute that that was created under HB 5066, but what we do dispute is that HB 5066 permitted the build out of this entire 765 kV transmission line and determined that need. And so we ask that the commission revisit that and take a closer look. Like I said, before committing Texas to an unprecedented build out of these lines that is akin to hauling water to the sea when we have the ability to create local dispatchable generation in the Permian Basin itself. Thank you.
Thank you.
Good morning, Commissioners. My name is Cahil Murchison. I represent Lazy Leven Ranch and a variety of others on both of these lines. And full disclosure, I did not mean to sign up to speak today, and I would rather cede my time than stick my foot in my mouth. Thank you.
All right, thank you.
Thank you. Could the following parties come up to the front? VBar Limited, Pigman and Daughters Ltd, and Oncor. While they come up, after this we'll take up 59315 speaker queue, and just as a preview of who's first for that, it will be Bagley and Company Properties, Whitehorse Christian Academy, Bird Family Farm and Ranch, and Joanna Friebele.
Ready?
Yes, please.
Good morning, Mr. Chairman, Commissioners. I would begin with the request of everyone here and that is I would.
Can you
respectfully
identify
request-
yourself?
I would respectfully request.
Sorry,
So
could you
your name and who you are.
Oh, sure. Sorry about that. Good morning, Chairman, Commissioners, Zach Brady for Vest and Pigman and VBar. I would respectfully request that please, nobody here, tell my wife how seriously Kevin Kennedy takes requests from his wife. Because I just can't meet that level of seriousness. VBar and the Pigman and daughters support the PFD. We'll refer the commission to our arguments on route earlier. I'm here today to answer any questions if the commissioners have any, and I yield the rest of my time.
Oncor?
Supposed to be. Okay. I didn't realize you were speaking for two. Good morning, Commissioners. My name is Jaren Taylor. I'm here on behalf of Oncor Electric. Time is short, so I'll jump right to it. There are rules that govern this process. There are rules that govern both how you act and the service that we are required to provide. One of those is the APA. It requires that your decisions in these cases be based on the evidence in the case. And so I want to talk today about the evidence in the case, in particular about the need for the case. We also have Public Utility Commission of Texas rules that tell you how to weigh that evidence. If you look at 25101 B3A Romanet 2, it tells you that you have to provide great weight to the recommendations of ERCOT in these proceedings, in particular on reliability projects, which is what this is. We're not talking about dumbbells for bicep curls. This is evidentiary weight. You have to provide great weight to those recommendations. So what are those recommendations in these cases? You have several. You have the Permian Basin Reliability Study, a study that went on for months and months where ERCOT looked at what was necessary to serve the Permian Basin. What is the recommendation you're required to provide great weight to? It includes Import Path 1, which is the exact project in front of you for approval today. Study number 2, you have the comparison that is done between 765 kV and 345 kV for those import paths ordered by you all, conducted by ERCOT. A separate study, it has a recommendation that you are required to give great weight to. That recommendation is that you use 765 kV and that you go forward with import paths 1, 2, and 3. 3, you have the 2024 RTP. These are all attached to the Oncor testimony in this case. 2024 RTP is a separate study, a regional transmission plan of the needs of the transmission grid as a whole. It again confirms and recommends import paths 1, 2, and 3. And I realize we're just talking about 1 today, but they are all included in there. And it recommends them as necessary for the reliability of our Texas electric grid. The fourth one I want to talk about is a little different. Each of those first 3 studies I mentioned is looking prospectively at our transmission grid years into the future. The last one isn't. The last one is a determination of generic transmission constraints that exist. This is a problem on your grid today, not tomorrow, not any other day. It's a problem that exists today. One of the people who spoke before me was correct. I think it was Judge Huckabee, where we have to look at what has changed. Well, what has changed in West Texas is the problem has gotten worse. With every 3-bedroom house, natural gas well, and caged chicken that we integrate into the electric grid in West Texas, we make this problem worse. We have too much load and we cannot import sufficient power underneath the thermal limitations of the grid. ERCOT has told you what the solution is to that. It says it directly in the attached ERCOT presentation. It is the Permian Basin 765 kV projects. That is the exit strategy for the IROLs or GTCs. There can be no better argument for a reliability transmission line than load shed is required if it is not built. That is our situation. Commissioners, let me just close by one other rule. Electric utilities in this state have a requirement that they provide electric service. We cannot do that if we are not able to build the infrastructure that your grid operator tells you is essential to provide that service. Thank you.
Thank you.
Right, that is all the speakers who have signed up for 59029. While we switch the display to 59315, I'll call up the next names. That's Bagley and Company Properties LLC, White Horse Christian Academy Inc., Bird Family Farm and Ranch LLC, and Joanna Friebele. After that, Emily Martin Howell, Broken Land and Cattle, CMF Investments LP, and Billy Mack and Kaylee A. Swansea. That will be the next group after this. Great.
Good, okay.
Bagley and Company.
Who's first? Does it matter?
Bagley and Company, sure. If guess not. In that case, White Horse Christian Academy.
My name is Vanessa Hofford, and I am the Executive Director and owner of White Horse Christian Academy in Stephenville, Texas. In June of 2025, I was notified that a 765 kV transmission line was being considered in placement on our property between our home and our school. Our school is built on our property. At the informational meeting, I was discovered something extremely concerning. The maps being used did not show our new $4.7 million school building that was built this last year on the maps. I immediately contacted Oncor. I provided the paperwork I received at their meeting, and I emailed 2 additional Oncor representatives to explain that their topological photographs were not current. I never received a response. I heard nothing further from Oncor until January of this year, when I received another bundle of maps. I immediately began the intervener process. I spent the spring preparing testimony briefs and jumping through every hoop I could jump through. In May, I attended the Oncor hearings in person and testified about my concerns. I explained that our school was not represented on their maps and that the proposed line would only be 247 feet from the playground, and that the parents were already expressing concerns about potential health and safety issues. I also raised concerns about transmission line workers having appropriate background checks when working so close to young children. Encore's response to my concerns is that they would negotiate with me if the line was selected. My line is currently the best meets line, is what Oncor says. But the health and safety of my children and my school are not negotiable. I have spoken to the Senate, the House of Representatives, and now I'm pleading for you to hear me. The proposed line essentially bisects the property in half. My home of 40 years is on one side, and the school that I have spent the last 10 years is on the other. White Horse Christian Academy has grown from 13 students in 2016 to nearly 300 today. We are an important part of our community, providing a Christian education and serving families throughout Stephenville and the surrounding area. If Encore's maps had been current, they would have seen our 19,000 square foot building, our playground, and where our future expansion is planned. Instead, I am now facing a devastating choice. Do I risk the future of my school that I have built the last 10 years with my retirement funds, or do I begin thinking about leaving my home where I've raised my children? There's no good negotiation between these two. Excuse me. I understand that Texas needs more power. I understand the importance of strengthening our electric grid, but there has to be a better process. Landowners deserve accurate information, and communities deserve to be heard, and decisions and consequentials should be based on what actually exists on the ground today, not on photographs. I'm almost done. So today, I'm asking you to push pause. Please give us the opportunity to work together to find a better solution, one that provides the power that Texas needs without destroying our homes, livelihoods, and schools. I am trusting God with the outcome of this, and I'm praying for each one of you because I know this is difficult. My dad always taught me that when things get rough, all you have to do is sit still and listen. Commissioners, I hope you do that today. I'm done.
Thank you.
I'm done.
Good morning. My name is John Marks. I'm a intervener on behalf of Bird Family Farm and Ranch LLC and my siblings, and also another pro se intervener, Thomas Tutt. I guess, most of my concerns have been well documented through every step of this process since we were notified at the public meetings last June. Filing protest letters, request to intervene, direct testimony at the hearing of the merits, closing brief, final brief, and all of these things are pretty consistent as far as what our concerns are about this process and about some of the things that we feel like would need to be changed. But just in general, let me say that we do give our full support to Route 559 as best meets. Basically, because it would avoid the devastation of our property by following one of the routes that use Route Link H22, okay? And that's the one we've been fighting against. And, but I do that with a heavy heart because I realize that no matter what happens, somebody else will get hurt if that happens, okay? But we are trying our hardest to protect our family's legacy. That property's been in our family for generations. And, it's like I said, we're just trying to protect what we have and keep it from being taken from us, okay? My first area of concern really has to do with the notification process that took place. I think the administrative law judges were pretty clear in their ruling that was completely insufficient. And I just wanted to tell you my personal experience. My father passed away in July, the 1st of July of 2024. Almost a year later, we receive an innocuous-looking letter in the mail addressed to him at his former address, and we just happened to get it out of the mail and actually open it, read it, and go, oh my God, we've got to go to that public meeting in Big Spring. And we did, and we realized when we looked at the photos that the line was drawn directly over our house, over our only stock tank, through the middle of our water well system. It would totally gut the property, okay? Anyway, we started knocking on doors and talking to our neighbors, and not a single one of the 10 surrounding landowners had any clue that this was going on, not a one. And that tells me that there wasn't very much effort made. So what I would like to suggest, at least, that the PUC may want to revisit their rulemaking process to make sure that landowners are notified and that it is verified that they're notified, okay? Because that would have made all the difference for people that probably missed a chance to do what I'm doing today and tell people what we think, okay? So that's the essence of my proposal. And I would like to say one last thing. Yes, the Permian Basin has more gas than they know what to do with. And certainly looking at local generation should have been something that was considered, even though I know that's not under your purview. But still, you need to locate the generation where the need is, okay? All right, that's my final say.
Thank you.
Good morning. My name's Joanna Friebele, and I've come before you before. And this time I have nothing prepared. Usually I'm prepared and I can read off my notes, but this time I have nothing. I'm tired. All these people are tired. Everybody is tired of this process and how it has gone, and it's not your fault. We need to have closure on this. We need to have delay, deny, or move on. I got into this 2 years ago at Senate hearing. I was in a Senate hearing going to talk on something else, and the Permian Basin plan came up. And it was like, wow, all these people are so excited about this. What's going on? So I had to start looking into it. So 2 years I've been looking into this. The first thing I saw was no legislative oversight on this bill, 5066. And it took me 3 to 4 months talking to different representatives and senators, and nobody really knew anything about it. And to me, that was the first red flag. And It was kind of like, well, don't you know what's going on? Of course, a lot of them would not admit that they didn't know about it. They'd signed the bill. And now people are realizing what's going on. And 5066, as you know, did the plan. It was not a mandate. Certain people like to say it was a mandate, but I see that's gone away recently. They're not mentioning that anymore. But it's not a mandate. It was a mandate that ERCOT do a plan. The plan was already in motion long before that. And so we got the plan. It only addressed transmission, and I know, as has been said, that you are not in charge of generation, and neither is Oncor. And ERCOT can't dictate what generation we have. But our legislators should have. And I don't know how that needs to be brought up to them, that they need to discuss that. They need to look at amendments or revisions to how the system works. We can't keep putting wind and solar on the system. We're going to get more and more unreliable. And anyway, that was my first red flag. Then a year later, the notices came in. And my local people, everybody was notified, or a lot of people weren't notified. Out of the first meeting that we had, I think out of 40-something people, 18 people said they didn't get the notification. A lot of them probably threw it away because it was this innocuous little letter, and they thought it was junk mail. They didn't deal with Oncor, so they didn't have any reason to open the envelope. If they had put a big stamp on it, urgent, you need to pay attention to this, time sensitive or whatever, on the envelope, that little tiny thing would have helped. People would have paid more attention. It doesn't take very much in the planning effort to do something like that. Anyway, I'm out of time.
Conclude your thought.
There's a lot of thoughts. I could go on for the next day. But, and like I said, our community has come together where everybody was divided at first in our community, put it here, put it there, our community came together. And as you can see from the people sitting here, Erath County is well represented. And I love that our communities come together to work with this, and we're here to work with you too. And I appreciate you. Thank you.
Next group, Emily Martin Howell, Broken O Land and Cattle LP, EMF Investments LP, and Billy Mack and Kelly A. Swansea. Could you come up, please? While they get settled, we will wrap around back to the end for anyone whose turn we skip. So please don't leave. We will come around back to you.
Thank you. My name is Emily Martin Howell. I'm in from Lincolnville, Texas in Erath County. Thank you for the opportunity to be here today, for another opportunity to have our voices heard. You have seen many people here today who are concerned about this proposed project. I'm here as one of them. I stand as a landowner, a face directly affected by the proposed dinosaur line, link C3 and C8. The Best Meats Route 559 was recently the decision given by SOA. I want to share with you my story and my concerns. I was legally notified by mail, postmark of February this year, but not aware of the project except by a neighbor on March 9th of this year, less than 30 days before the deadline to become an intervener. Like many landowners who do not do business directly with Oncor, I had previously disregarded the packet from February as junk mail. Since March 10th of this year, I have been actively involved in advocating and helping others. I've had the honor to work with many other volunteers to help our fellow neighbors to have their voices heard, to defend their homes, their businesses, their schools, and their family legacies. We've had to learn how to navigate a system that is not user-friendly to pro se in a limited amount of time. Not only did I have to file mine, but our volunteer group filed on behalf of several hundred other people across our area. Before those filings, we had to educate people how to advocate for themselves. We had over 1,300 interveners file. Unfortunately, as you know, over 700 of them were removed from the case from SOA for one reason or the other. I hope this information and those numbers pique your interest and you research this process and help make changes on behalf of the public that you serve. There should never be a time when neighbors have to advocate for themselves and their neighbors in a matter of this scale under this timeline. There should never be a time when people have to stand, when the people that stand to profit the most at the cost of others are the ones calling the shots. Oncor admitted in their testimony at the House hearing yesterday or Wednesday that they ordered the parts for this 3 to 4 years ago. What does that tell you? The unified request is that we ask you to acknowledge this project needs review. It needs more time and a plan to generate more localized power without moving it around the state. I plead with you on behalf of all the people that I represent to please just take the time. There's no reason to rush decisions that are affecting so many people. When we sat in the House hearing, the guy that authored that bill told us, he said that the 180-day timeline was never to be used. They never dreamed it would be used at this scale. But if you can see, you gave Oncor an inch and they took miles and homes and things that they don't care about. So please just take the time that you feel like is needed to represent the public that you serve. And I thank you for your time.
Thank you.
Joe Will Ross here on behalf of Broken Oak. I will not speak on the route. Y'all have already heard my words. I'll say this, as a landowner who has gone through the CREZ process before and who is probably going to be in the study area when we do Howard to Bell County East. I think most everybody here would agree that we want finality. Yay or nay on need, picking a route. We don't want to do this again. The waste of time and money that landowners, pro se interveners, clients, and everybody involved would admit that this has just been a tough ordeal from mid-December through June 26th this year. I think we just need to make a decision and let's live with it. But we'd like finality and certainly do not want a do-over. Thank y'all. I yield whatever time y'all deem necessary.
Good morning. Thank you for your time, Commissioners. I'm Mike Craddock. I represent CMF Investments on Link F32, and we're in support of the 552 modified route. I guess today I'm here representing an issue that's possibly the least sympathetic, but also quite important, and that being the Texas pimpleback mussel and the Texas fat mucket mussel. Those are both endangered species. They both exist on Link F32. The purpose of me asking for this time is to highlight an issue that appears only on page 77 of the proposal for decision, and it references a footnote 296. And what's important about that is that the administrative law judges acknowledged the concerns and the existence of these two endangered native species. They acknowledge their existence, but opted instead of acknowledging that existence to go with an endangered species assessment that was done earlier. But my point in bringing this up is I don't want something that's in one sentence, in one footnote, to be overlooked by the deciders, and that's who you are. And as good as your staffs are, and as emotionally important as other issues are that have been raised, that's something that could be lost in the shuffle. So what I would like to bring to the Commission's attention is that the Texas pimpleback and the Texas fat mucket have previously been litigated before the Commission in a situation where Oncor was wanting a power transmission line to come through, and they lost. I mean, this Commission previously ruled that, well, you're not going to put a power line through this area. So that's something that, and I'll refer you to the docket number. That's PUC docket number 37530. And there's precedent from this Commission that's decided that this is critical habitat and you don't need power transmission lines running through it. they're also, if you'll, I don't know if you can go back and look at your stuff or if it's allowed, but there's published research on it. There's documentation that these species exist. Now, I almost feel like the Lorax here, who's going to speak for these mussels that are swimming around the bottom of some river? Well, it's important. There's very few habitats. And the facts are, the thousands, if it's thousands of miles of alternative transmission lines that have been proposed. This is the only segment where there are known, native, endangered species previously acknowledged by this commission as being worthy of protection. It looks like I'm out of time. I talked longer than what I think. But what I would like to say is basically the administrative law judges said, well, for the purposes of our methodology, we're going to use this the endangered species assessment and conclude that there are 0 endangered species along the line. The facts on the ground are the contrary. The facts are known by this commission. The facts were known by the hearing officers who did the best they could, but they effectively said, hey, we're going to use this methodology. And by using that methodology, we say there's 0 endangered species when the known facts are that these species exist in this location. And if you'll look at, I believe the Campbell Family Trust filed some affidavits that talked about, in more detail about this issue. But the point is, the administrative law judges used a methodology that should not be applied because it ignores facts on the ground that they're important. I mean, a lot of people say, well, the world probably doesn't need any more mussels, or who cares about the mussels? Well, it's more fundamental than that. Are endangered species a real deal? Are endangered species something that Texas is willing to protect? And they should protect them. And this is an opportunity for this commission to take a stand for that. Now, I'm not some kind of tree hugger. I'm just telling you that's an important issue. There's less and less habitat, and this will impair that. And we ask that the commission adopt an alternative route, specifically the modified 552. Thank you for your time. And I apologize for running over.
Thank you. For Billy Mack and Kelly Swansea, we will circle back on this. Okay. Yeah, come on up. Okay. All right, you represent Billy Mack and Kelly. Great. And state your name for the court reporter, please.
Am I on?
Yes, sir.
Good morning. Commissioners, I'm Robert Wagstaff. I'm a lawyer from Abilene, Texas, which is just north of Buffalo Gap, Texas. I represent the Link H11 interveners, which are a group of landowners in Buffalo Gap, and as well as the Beckham family Spring Gap Ranch that is just east of there in Callahan County on the Callahan Divide. If you'll indulge me just a second, in 1886, my great-grandfather wrote home to his parents in Tennessee that Buffalo Gap was a pristine area, a hamlet in the arid regions of West Texas, of live oak trees, grasses, and an abundant wildlife. And I suspect that the views based on his writings to my great-great-grandparents, that the views we have today in Buffalo Gap, thanks to many of the citizenry that have lived there all these years, is still very similar and the same. And I hope for my great-grandchildren that they have the same view that I have and that my great-grandfather had. Now, I say that to say this, that's a community value issue. That's just one of the factors that plays a part in what the ALJs had to decide, right? Well, what we saw in a lot of the exceptions, what we saw from PUCT staff's own engineer, Mr. Acosta, that community values, he hung his hat on that. And if that was the only reason, well, then none of these lines would be going through any of these places. I mean, because everybody has community values. Everybody has what they love and what they, you've already heard some of that testimony and argument this morning. But that's not the only factor. And we saw in these exceptions from a lot of people to the ALJ's decision that relying on that Route 713 that Mr. Acosta, that he sponsored, was based on these community values. And I would point out that Judges Shenoy and McCabe did an outstanding job of sorting through a lot of testimony. They were the triers of fact, just like a jury would be. And what they found is that Mr. Acosta was uncredible. In fact, they specifically said that his opinion lacks a solid grounding in the evidence. That's because that's all he figured. And he didn't even compare the community values in his route with the community values in Buffalo Gap or any place else. He couldn't say that he did. And so they specifically stated that they had to carefully review his testimony, and it was important to explain why his opinions do not carry weight in the analysis. So anybody that comes up here or anything that says that 713 is somehow supported by the evidence is simply wrong. They did it right. They did a great job. It was a thorough opinion. They looked at everything, and we certainly support 559, and we thank you for your time today.
Thank you, sir.
Next group, Earl Donnell, Michael P. and Jacqueline A. Failer, Beckham Family Ltd. Partnership, and Lance Joe. Lance Trinke, please come to the front.
Those are part of my group.
Oh, okay. Then
They're part of that Link H11 and the Beckham family, like I just mentioned. So I don't think I'm allowed to speak on every one of them, or I'll be here for 45 minutes, which I'm happy to, but I will reserve the remainder of my time. Thank you.
Thank you.
Just me.
Good morning.
Good morning. Right. My name is Lance Trink. I'm from Erath County, Texas. Just a common man just trying to say things in a simple way. But when I think about Texas and what it means to me, I think about the land and how my grandmother said to love it, to take care of it. I believe that this is a core belief of every rural owner of land in Texas, from the iconic hill country of the Edwards Plateau to the Blackland Prairies and Cross Timbers, and all the way out to the Llano Estacado. Texas is loved, it's cherished like a dear family member. Raised in that belief and coupled with a work ethic that promises if you save and plan and pray, someday you could acquire a small part of the land you love and pour your heart. And dreams, sweat, and life into it, pass it on to the next generation. Now imagine you were informed by a neighbor that the largest power line ever built in Texas was a bisector dream, destroying a swath 200 feet wide and ruining the rest. I thought my neighbor must be mistaken. Texans would never do that to other Texans. What's happening to my beloved state that it would ever consider such a terrible thing as this? Like everyone else in the room, the next year was an education. My shattered, naive idea that everyone in Texas believed as I did, I learned that about money-hungry, out-of-state conglomerates seeking opportunity to exploit natural resources in rural areas with no laws in place to stop them. I also learned about politics and politicians, along with utility companies willing to jump on the gravy train at the expense of the rural Texan. I learned there were people willing to destroy thousands of acres of pristine habitat critical to endangered species of Texas wildlife, and a governor that would, with the power to silence that department that protects this wildlife. As I heard Tanya Tucker say, Texans don't do this to Texans. Scarring the face of our beloved state and destroying land that is dearly loved, every inch of this 765 transmission line and every 200-foot tower would be a monument of terrible decision-making in our state government and a constant reminder of shattered dreams of Texans who believed in what they thought could be never be taken from them. I'm a retired 38-year veteran of the fire service, looking forward to the serenity and peace of a lifetime of public service. Like many other older retired Texans, those dreams are apparently of no value to this new Texas mentality of growth at all cost. Can't we slow down, reconsider, and fully study how every option could be made to work? Instead of one that affects so many hardworking rural Texans trying to live out their dreams in a state they thought they loved, or the state they loved and the one they thought loved them too. Thank you.
Thank you, sir.
Next, my understanding then that Link H11 interveners are spoken and accounted for. Moving down the queue to Middle Trinity Groundwater Conservation, American Stewards of Liberty, Jack Bell, and Great Southern Ranch.
Who's first?
Middle Trinity, please.
Good morning, Commissioners. Jake Steen on behalf of the Middle Trinity Groundwater Conservation District. In light of your proposal and ruling earlier today about addressing the need that is not of the interest of the Middle Trinity Groundwater Conservation District, we're strictly concerned with ensuring that their proposals in the decision are of the protection of the groundwater resources in the proposed route as outlined in the proposal for decision, and we yield the rest of our time, respectfully.
Good morning. My name is Elena Fulgaris, and I'm here on behalf of American Stewards of Liberty. I'm not going to repeat what I previously said for docket 59029, but what I will say is that I would urge the commission to defer the need determination within these two dockets until docket 59475 is before the commission. These 5 dockets, these 5 pending dockets, were all created under the same Permian Basin reliability plan, which determined that all 3 of those import paths were needed. As a result, these dockets are interconnected projects, and the need determination cannot be determined on a line-by-line basis. So we would ask that the commission withhold any need determination until 5947 is before you. I also wanted to briefly touch on the notice issue that has come up within 59315. The PFD found that Oncor failed to comply with the commission's notice requirements, and that is not a technical defect. Notice gives landowners the opportunity to participate when that participation actually matters. And as a result, there's only one meaningful remedy. Discovery, testimony, hearing, and briefing are all complete. Extending any sort of intervention deadline or any sort of other remedy now at this time cannot restore the opportunities that affected landowners lost to develop evidence, conduct discovery, and cross-examine witnesses. The last item that I want to touch on today is about that 180-day timeline and how that affects these landowners' due process rights. These proceedings required hundreds of landowners with distinct property interests to navigate discovery, testimony, hearing, briefing, a full PFD, and this commission review like we're here today, all within 180 days, and some of them without counsel, some of them figuring this out on their own because of the number of people that were affected. All of the counsel that would be able to participate in these hearings had already been engaged. And, you know, I know I'm a bit young for the CREZ lines, but I do want to look at those lines as a quick example. And with those lines, the legislature had first made a policy decision where SB 20 expressly stated in its plain language that the commission was going to develop a plan to construct those transmission lines. And they actually removed that need determination for the CREZ lines. That didn't happen with HB 5066. And so we want to make sure that this need determination is fully looked at. And so that is why we are asking for that deferral until 59475 is before the commission. But regardless, we do believe that this docket alone, 59315, should be denied on the basis of the notice deficiency. Thank you.
Good morning. My name is Jack Bell. I'm the co-owner of tracts 4892 and 4893 in Comanche County. Link D71 will cross across the northern edge of those two properties. Link D71 did not exist prior to December of 2025. As such, it was not part of the information provided to the public for public input and was created to address the concerns voiced during those earlier public meetings. I had no opportunity for input. It would appear that there was very little actual study performed of the path selected for D71. Had an actual study of the topographical aspects of the route selected been performed, it would have become obvious that the path included not one, but 3 crossings of the Nanny Branch on my property. I also included in my testimony that additionally there were 2 springs and a cave, along with numerous elevation changes in the selected path, which Oncor states is the best path. Had they drawn their line 200 feet north on the other side of the fence, 2 bends, both springs, the cave, and a small canyon could have been avoided. I brought this up in direct questioning of the Oncor staff during the PUC 59-315 hearings. The response was a flippant, "We'll know more once we have boots on the ground." Oncor also testified that they had had a helicopter survey the route at 1,000 feet AGL, and it also looked for unregistered airstrips along the routes. They somehow missed my airstrip, TA-45, which is now registered with the FAA, which was a 7-month process, 1,000 feet to the south of their proposed path, along with the bends in the Nanny Branch. I was looking forward to their shock when they actually encountered the terrain they had testified as their best path. I've been unable to walk it in 23 years. Until I found the Oncor easement right-of-way, Form 50.3200, posted on the PUC website. From that document, grantor recognizes that the general course of said lines, or the meets and bounds as described above, is based on preliminary surveys only. And grantor hereby agrees that the easement and right-of-way and its general dimensions hereby granted shall apply to the actual location of said lines when constructed. Now I know why they were so arrogant. No need to actually perform a real survey and plan. Just draw a line on a map, get the courts to force an agreement. Once they get boots on the ground, they can take what they want, and the property owners have no recourse. This can't be right. Thank you for your time.
Thank you.
Want a microphone? There you go.
Good morning, Chairman Gleeson and Commissioners. My name is Paige Castleberry, and I'm here on behalf of my family and the Great Southern Ranch in Erath County. The EA submitted by Oncor is based on outdated, inaccurate, and incomplete information, including appraisal district parcels. This stale information hurt landowners along the fast-growing Stephenville area. This failure violated the Commission Rule 22.52, requiring notice to the landowners on the current county tax rolls at the time the application is filed. In fact, the EA excludes the uncontroverted record evidence of 12 additional habitable structures and a golf course open to the public on Route 552 and 11 habitable structures on 559. Oncor also failed to recognize that Stephenville expanded its city limits prior to 2023, unknowingly allowing the route to go through the city limits. The EA further fails to account for a residential development under the construction 400 feet from Link C3, a planned infrastructure project, the runway expansion of our regional airport, and the city's growth along its northern and eastern boundaries. This information was not only public, but readily available. These failures by Oncor greatly underestimated the true consequences of the Best Meets route and the ALGJ's PFD, particularly as it relates to Stephenville and surrounding area. The swell of opposition of C3 from the people in our community reflects the impacts of a 765 kV line crossing into a densely populated area such as Stephenville, where people live and work. I was very happy to hear the chairman testify yesterday that he would not support cutting through large generational ranches because in addition to all the ranches, neighborhoods, schools, and recreational areas around Stephenville, this line would slice through the Great Southern Ranch almost in half along 2.88 miles. Moving the route further south would cause the line to run closer along the Bosque River for that length, which would have hurt the metrics in the EA. Instead, it cuts through GSR's most productive fields. My grandfather bought the Great Southern during World War II, and my daddy grew up on it. My dad and mom returned after Daddy finished his service during the Vietnam War. My family have all grown up learning to be skilled stewards of this great ranch. Please don't take my family's heritage and legacy by choosing a route that goes through the Great Southern Ranch. Thank you.
Thank you.
Thank you. The next group, Frank V. Terrell, Aggravation Partners 2 LP, OPUCT, and Little McMountain Ranch LLC.
Chairman Margaret Pemberton. Dr. Terrell and I are going to share our time. So should I just start after he?
That's fine. They're going to share their time.
Chairman Gleeson and commissioners, I appreciate you allowing me to speak. My name is Frank Terrell, and I'm testifying or speaking on behalf of myself. This line will devastate our four-generation ranching operation. My father purchased this ranch during World War II, as Paige indicated, and I grew up working on it from the time I was able to get around, really. I started driving a tractor at age 10. My family and I put our lives and souls into this ranch. We have 3 generations living on and working the land together. And please don't let this happen to my family. Thank you.
Good morning, Chairman Gleeson and commissioners. My name is Margaret Pemberton. I represent both Great Southern Ranch and Dr. Terrell. Although the commission had 180 days to decide this case, so insisted upon 2 months after the hearing to file the proposal for decision. The already compressed schedule was further compacted to accommodate the judges. That time was taken away from the interveners, reducing the time to trial by approximately a month by comparison to CREZ. And so was scheduled only 1 week for a trial for an expected 1,300 parties. The interveners did not have time to present their cases and really be heard. Interestingly, the ALJs did not meet their own deadline, but were very unforgiving about the intervener deadlines. CCNs have always been about people, not numbers or calculations, but about people's family and land. Oncor used numbers for the environmental assessment to compare the different routes on a quantitative basis. But those numbers were wrong, and Oncor would not accept the proof from the landowners to update the EA. They left it to the ALJs and the commissioners, but the ALJs wouldn't even look at that uncontroverted evidence. Comparing the real uncontroverted evidence, a route going through Stephenville is neither quantitatively better nor qualitatively better than any of the other routes. Oncor included a route that went around, not through Dinosaur Valley State Park. Oncor stated that it was actual compatible right-of-way and would not harm Dinosaur Valley in any way. And many of those routes had fewer habitable structures and were less expensive. Staff suggested a route that was more expensive, but balanced the agricultural needs of the area and avoided Dinosaur Valley. He had many bases for his recommendation as outlined in the evidence and the hearing. and the briefing. And that route could actually decrease costs in the future in the overall planning of the transmission grid. But the ALJs chose the route through Stevensville. The legal analysis relating to notice to landowners from appraisal district data on the day the CCN is filed, and the analysis relating to the newly added landowners without opportunity for public meeting were argued in this case as well. The latest information related to the new generation, and I won't go into all that, I would like it reviewed before making an irreparable decision that affects landowners in this case. I urge the commission to look at the length of the family ownership and involvement of the owners for the large ranches. Please do not destroy Great Southern Ranches and Dr. Terrell's heritage and legacy. Thank you.
Thank you.
Aggravation Partners 2 LP.
Who's next?
Aggravation.
Okay, I'm sorry. My apologies. My name is Randall Terrell. My interest is in aggravation, and I represent my interest in Aggravation Partners 2. That land, my family's land, is designated as parcels 2712 and 2720 on the routes. We are on the C3 link and part of the 559 route that has been recommended by the ALJs. As proposed, the link would run 8,400 feet along and take the entire southern boundary of our ranch. I am proud to tell you that the gentleman to my left is my Uncle Frank. His dad and my grandfather was my grandfather's little brother. Last month, we were privileged and proud to celebrate the 100th anniversary of the hospital that our family founded in Stephenville. Frank is the last of the 4 Doctors Terrell that practiced in there for combined, 200 years. Our concerns, my concerns, are no different than Frank's, other than our ranch is on the other side of town and a little older. I oppose the ALJ's decision to approve the Dinosaur Longshore Line in general, any route through Erath County, the recommendation of Route 559, and any route that would include the C3 link. If you approve this route, this line, you are ringing a bell that cannot be run wrong. I do not envy you the job that you have. Y'all are between a rock and a hard place. If you approve the application, you'll upset hundreds of interveners, thousands of their family members and interested parties, and tens of thousands of their friends and neighbors. And all will feel like their concerns have been ignored and that they have been thrown under the bus. I cannot overstate how angry my family, my neighbors, and my friends are over this process and this proposed decision. If you deny the application, there will be uncertainty and delay, but you have a chance to do this thing right. The demand projections relied upon to approve the PFD are conflicting and inflated. There really hasn't been any determination of need. Even if there isn't enough generation to supply the line, and there isn't enough water in this state to support the power generation needed for this line or all the ludicrous amounts are forecasted in applications in the ERCOT dashboard right now. There is no plan on how to address that need. The process has been rushed, tone deaf, and has made a mockery of the idea of public notice and participation. Any claim that the scant 4 public meetings held in an area that comprises hundreds of thousands of people, tens of thousands of square miles, and were held a year before the filing of this application 59315 on a different route that did not, in fact, include a large portion of the route that is now considered on our property. The PFD is arbitrary and capricious. It relied on old maps that do not reflect current conditions on the ground. Testimony at the hearing established that Oncor and its contractors chose not to use the latest maps of Erath County out of alleged fairness to other routes. This deliberate decision and the choice not to use actual updated factual routing information has led to several ludicrous results. Further, whatever routing information in the PFD do rely on completely ignored many facts on the ground and used...
Finish your thoughts.
Okay. And used incomplete information that does not accurately reflect the information on the ground, the airport, the hazards to the airport navigation, and passing the route over the highest point in 60 miles, which is the ridge on 2712. Thank you.
Thank you.
Good morning, Chairman and Commissioners. My name is Courtney Jinks, and I am here on behalf of the Office of Public Utility Council. As you're aware, OPUC represents all residential customers and small businesses in Texas. Because of this, OPUC does not favor the rights of one landowner over another and will not recommend a proposed route in this case. Instead, we urge the Commission to protect the rights of landowners and small businesses by maximizing usage of any existing rights-of-way and selecting the route with the least impact to landowners possible. The largest obstacle we have seen in this proceeding is the compressed timeline. We recognize SOA and Commission staff's own time constraints under the statutory 180-day timeline, and we appreciate their efforts to assist interveners in this process. However, the efforts only mitigated a small fraction of the harm caused by the compressed timeline and Oncor's unwillingness to extend that default timeline. In this case, a procedural schedule was set 10 days before the intervention deadline. After the intervention deadline, parties were only given 4 days to submit a route adequacy challenge, 7 days to object to Oncor's testimony, and 15 days to file testimony of their own. In their order adopting the procedural schedule, the ALJs did notify parties that they would be dismissed if they did not file a statement of position or testimony, but this means a landowner unfamiliar with this process only had 26 days from learning of this requirement to being dismissed from this case. Of note, SOA adopting a procedural schedule that dismissed those that failed to file testimony or a statement of position was permissive and not mandated by any statute or commission rule. 600 Texans were dismissed from this case because of this procedural hurdle. Given the number of parties, complex issues, and filed documents involved, 180 days makes it incredibly difficult to fully litigate the issues at stake. In light of these challenges, the Commission should exercise the utmost care when considering this application. This segment of Import Path 1 is estimated to cost more than $2 billion alone, and this is before any routing adjustments to accommodate landowner needs. Residential landowners and small businesses are not the main cause for these infrastructure expansions, and the Commission is required under PURA to consider the probable improvement of service or lowering of cost to consumers when considering a CCN application. We urge the Commission to select the most cost-effective route that protects the property values of the landowners and environmental integrity of the affected land. We also urge the Commission to uphold its rules on routing that address paralleling, compatible rights-of-way, and prudent avoidance. Lastly, OPUC remains concerned with Oncor's failure to meet its public meeting notice requirements. Commission rules recognize the right of all impacted landowners to be given the opportunity to have their voices heard in a public meeting prior to the application being filed. Oncor's failure to notify landowners that were affected by its modifications after the June 2025 public meetings does not meet Commission standards. The public interest cannot be championed if the public was never fully apprised of the application to begin with. At OPUC, we take our mission to serve the residents and small businesses of Texas seriously, and we urge the Commission to give their concerns adequate weight in its consideration of this case. Thank you, Commissioners, for your time this morning.
Thank you.
Thank you. Next, Little McMountain Ranch LLC, Blaine Christopher, Toller ISD, and Adrian and Joanne Campbell Living Trust. The mics are pretty forgiving. They can be a bit away from your mouth.
My name is Meredith McCall, speaking for the Little McMountain Ranch LLC and Walter McCullough. I am a civil engineer, a landowner with 2 properties affected by the 765. I'm a 9th-generation American, a 7th-generation Texan. My patriot, Peter Sides, was one of the very few who fought in both the American Revolution and the fight for Texas independence. He died in 1813 at the Battle of Medina, known as the bloodiest battle on Texas soil. The reason it is known as the bloodiest battle in Texas is that Spanish General Arredondo, out of disrespect for the Texans, left Texan remains on the field of battle for several years until they were finally buried in 1822. Today, I am representing thousands of disrespected Texans and landowners, including our family, Little McMountain Ranch LLC, and families who did not receive fair notice, input, or a seat at the table for these projects. Our family has been farming and ranching on our Comanche County property for over 100 years, and we will suffer from uncompensated property value loss if this line is built on the D32 segment. We are not unique. There are estimates that uncompensated property losses are expected to exceed $10 billion if these projects are built. We do not agree with the ALJs on their assessment on need for the Dinosaur to Longshore project. Oncor relied fully on ERCOT's planning study, the Permian Basin Reliability Plan, to justify their need for the project and didn't supply their own burden of proof for the need. I ask you, how can a landowner in a SOA case question the need on a certificate of convenience and necessity case when ERCOT is not a party for the SOA case? And Oncor has not completed its own determination of need. PBRP is clearly a study that has not explored all alternatives, including natural gas generation. HB 5066 did not mandate this project. Oncor points to HB 5066, PBRP for their need, and yet Oncor misrepresents and inserts words, omits words from HB 5066 to fit their agenda. I argue that because Oncor cannot answer for ERCOT's PBRB study for the need and incorrectly misrepresents HB 5066 in the case, this makes PBRP hearsay. ERCOT's PBRP recommendation is not entitled to great weight here. I implore the Commission to do what is right and deny the 765 cases, including 59315 and 59029. I agree with the assessments with over 40 legislators that say these projects are wildly outside of the scope of HB 5066 and should be denied. Thank you.
Thank you.
Commissioners, thank you all. My name is David Cook. I'm with Toller ISD. I'm a trustee. I'm not here to talk about need. I'm not honestly qualified to talk about need, but I did want to talk about route. And school is in session today, and the students and staff most affected by this decision couldn't be here. I ask you to keep their interest in mind. I'm not here to push one route onto our neighbors. Every option affects families, farms, and landowners, including people in our own tax base. I'm asking the Commission to give real weight to the ALJ's independent recommendation, especially before choosing a route that adds impact to our schools. Tuller's population is around 900. Tuller High School alone has close to 300 students. But that undersells it. Our junior high and elementary kids utilize those facilities during events or graduations or other things like that. More people gather on that campus than live in the whole town. This school is the center of our community. PUC's own rules recognize schools as habitable structures, use 500 feet as the effective structured distance for lines above 230 kV, and call for prudent avoidance, limiting EMF exposure when it can reasonably avoided. EPA guidelines independently point to that same 500-foot distance as worth evaluating near schools. And there's Texas precedent. In Docket 31011, avoiding Danny Jones Middle School was cited as a benefit of an alternative route, even though it was longer. We've looked at existing 765 kV lines nationally and haven't found a school that's K through 12 publicly funded within 500 foot of one. I'm not saying that proves anything about safety on its own. I'm asking a simpler question. If this impact to hundreds of kids can reasonably be avoided, why wouldn't it? The ALJ already recommended a route that avoids this impact, and it also is the less expensive option. We understand cost matters. We understand that bisecting farms and placing burdens on individual landowners matter too. But weighting all of that together, we are asking the presence of a public school and hundreds of kids on that property every day carry real weight. Any route the Commission picks will affect someone. We're not asking you to shift the burden onto our neighbors. We're asking whether it's necessary to run a 765 kV line this close to the center of our school when the ALG has recommended a different path. I'm also speaking on behalf of Mayberry Farms, Nick's Farms, Last Straw Ranch, and other community members that are affected by this. We respectfully ask the Commission to give the ALJ's recommendation substantial weight and protect Toller ISD from the impact that doesn't have to happen.
Thank you.
Good morning. Blaine Christopher for the C8 route, or the C8 link, Route 559, Best Meets. I've been filled with an immense amount of pride to be standing with the people who are here doing our best to be respectful of you all and of our great and growing state. If you're tempted to be frustrated by our fervor, I beg of you to remember we are fighting the noblest fight. With billions of dollars of odds against us, we are fighting for our livelihoods, fighting for our families and our water, fighting for the preservation of our culture and lands, fighting for a night sky where we can still see the shooting stars, where we can still mow the lawn without fear of cancerous electrical fields, without fear of an electrical arc that destroys equipment and human life, fighting to not have thousands of 200-foot reminders of generational theft. We're fighting to preserve not only Texas, but our lives. So please, I beg of you, reevaluate your positions in this plan and the need. To any aspiring whistleblowers in the room who might be employed or have been employed by the PUC, ERCOT, AEP, Oncor, Meta, Google, or even a data center, now is the time to join others like Brad Buckley, Senator Slauson and Sparks, and other senators and amicus briefs and speak up. There's still room in this Sunday's paper for your voice. Tell a story for Texas and in support of these, or in the support of the fight against these lines. Maybe this is a story of the PUC's ability to regulate Oncor and their Fortune 300 parent company, Sempra Energy. Or maybe current PUC organizational culture. Maybe long buried documents about potential harm of high voltage transmission. Maybe something or someone your company gave or received that just didn't sit right. Speak up, the time is now. On Wednesday, a Lansing representative stated, "We don't start building until we have a clear path to power." My ranch, my livelihood, and my happy place is that clear path. A path that was paved prior to being publicly identified. A clear path you're paving over hundreds of families' futures. We heard a lot from lobbyists about the cost to pausing or denying this plan. To that, I say something that my dad used to say to me. If you don't want to do it twice, then do it right the first time. Your process has been called flawed, unfair, and draconian. Even a past employee commented on the current culture of the PUC. What I beg of you now is accountability. Account for poor energy planning. Account for 20 years of bad energy politics, and go back to the drawing board. You want to talk about need, but I want to talk about accountability. It's clear you all have the power, but will you use it to do what's right? Thank you very much.
Thank you.
Good morning. Good morning, Chairman Gleeson, Commissioners. My name is Roger Borgelt, and I represent the Adrian and Joanne Campbell Living Trust. I first of all want to say that the Campbells, due to other circumstances and scheduling, could not be here today. They did, however, come and actively participate with me, their legal counsel, in the entire 6-day SOA hearing, and were actively involved, so they didn't want you to take their lack of presence here today as a lack of interest at all. They would have been here if they could have been. They did want me, though, to reiterate a couple of items of points that we made in our briefing and our exceptions, and some of this was covered by Mr. Crawford earlier, but I'm going to cover it again because the Campbells wanted me to. First of all, there's prior precedent that needs to be acknowledged in this case. The Campbell Trust owns tracts numbers 5778, 5779, and 5780 along link F32, which is on the route that was recommended in the proposal for decision. This particular area was the subject of an Oncor case that involved the Campbell property and in which the Campbells actively participated in 2009 and 2010. That was a Cresline case. It was the application of Oncor Electric Delivery Company, convenience and necessity from Bluff Creek to Brown 345 kV Cres transmission line in Taylor, Runnels, Coleman, and Brown counties. And it was PUC docket 37530. And in that particular case, the route was proposed to come through the middle of the Campbell Trust property, but because of the existence of endangered species on the property, and I'll get to that specifically in a moment, the administrative law judge and ultimately the commission found the route through the Campbell property not acceptable and chose a route in Runnels County several miles to the south instead. So the supporting evidence in that case previously used to route the line is still pertinent to this current proposal, and we believe the commission should rely on previous precedent in PUC transmission line cases in choosing its routing. And if the routing was not acceptable in 2009, 2010, then it shouldn't be acceptable today. Unfortunately, the Oncor experts, the administrative law judges, and the PUC staff failed to consider these previous cases in their environmental assessment. And in fact, as previous speakers have stated, the environmental assessment did not include a lot of the testimony that was actually included in the record in this case. The statement is in the proposal for decision that all focus routes have the same length 0 across known habitat is simply not true. It's not supported by the testimony or the environmental assessment. There is actually documented and in the record in our briefing evidence of the existence of endangered Texas fat mucket and Texas pimpleback mussels on the Campbell property. So it's not true to state that the line that's being proposed does not contain endangered species. It does. Thank you.
Thank you. So Commissioner Alex, before we continue, we've been going about an hour and a half as we typically do. Let's give our court reporter 10-ish minutes. So why don't we take a short recess and we will reconvene at 11:15. We'll now reconvene the open meeting at 11:17 a.m. Before we continue with oral argument, Commissioners, real quick, after we closed public testimony or public comment, another person came in. So what I'd recommend we do, let's finish with oral argument. Let's close out these 2 items and then go back to public comment and take that person up. Since they came here, I think it's appropriate for us to call that item back up and give them an opportunity to speak. Okay, Ron, does that work?
That works.
Okay, perfect. All right, Alex, please continue.
The next group, Herman J. Ledbetter Family Trust, Paul and Tony Burns Family LLC. Yes. Could you take a seat, please? Can you let me know, Paul and Tony, do you plan to, does each member of the collective D6, D3 Alliance plan to speak? You know, you represent all of them, so I should not call up. I should not call up the rest of the. Okay, great. In that case, moving down, Cowden Live Oaks Ranch LP and Porter Family Land Co. LLC, please. Thank you. And Herman J. Ledbetter Family Trust, begin.
Good morning, Chairman, Commissioners. My name is Paul Tuff, and I am here representing the Herman J. Ledbetter Family Trust. They are an intervener in this matter, and they own a 4,500-acre ranch called the Buffalo Mountain Ranch. And their property is not crossed by the Best Meats route. Their property is not crossed by the SOA ALJ's Best Meats route, but their property is crossed by a single focus route, and that is Route 713 and Link H11. And that Route 713 and Link H11 have a devastating impact on that ranch. And that route should not be selected for 3 main reasons that I want to talk about here, but there's more reasons in the briefing. So first, Link H11 through Route 713 bisects the Buffalo Mountain Ranch. It does not follow any property lines. It does not follow any existing transmission line corridors, although there are two. It does not follow any roadways, although there is one. It does not follow any compatible right-of-way whatsoever across that property. It enters the property and makes an almost 90-degree turn in the middle of the property as it exits and crosses over two transmission lines, a 138 and a 345. The 345 is in the process of being upgraded and was approved recently yesterday at the open meeting. That crossing of Link H11 on the Buffalo Mountain Ranch leads to the second point why Route 713 should not be selected, and that is the unresolved issue between that crossing, Link H11, and the Dyess Air Force Base. So when Oncor submitted their coordination with the Department of Defense, which would include the Dyess Air Force Base, they represented that the maximum structure height on Link H11 would be 190 feet. When Oncor filed its application with the PUC, it represented the maximum structure height would be 198 feet. And that issue has not been resolved with the Department of Defense or the Dyess Air Force Base. And there's evidence in the record to show that the Buffalo Mountain Ranch is within the restricted airspace of the Dyess Air Force Base. And then third, the environmental impacts of Route 713 are greater than any other of the focus routes. Now I'm going to highlight a couple of those points. And this is consistent with the unmitigated impacts that Link H11 has on the Buffalo Mountain Ranch. And that is Route 713 crosses more than double the woodlands of any other route of focus route. Crosses more miles of riparian areas, almost double, 30% more wetlands, 37 more stream crossings. It impacts 2 parks and recreational areas. It crosses more than 25 miles of areas of high historical potential. It costs more and impacts more habitable structures. So what we're asking here today, if you're going to approve a route, that it not be Route 713 and that it be the best meets route that the SAIL ALJs have selected, which is 559. Thank you.
Thank you.
Good morning, Chairman Gleeson and Commissioners. My name is Soledad Valenciano, and I represent the D6 D33 Alliance. It's made up of 7 landowners. For the record, the Paul and Tony Burns Family LLC, Pierce Burns, his wife Reba Burns, the 5G Land and Cattle Company, Joe Mark McCullough, Mark Perkle, Bill Reed, and Connie Prater Reed. We're here today to support the PFD. We believe the ALJs got it right. Before I go into oral argument, I do want to say that on behalf of my clients and myself, I do appreciate you giving us oral argument today. I know that's not always granted, and we appreciate that. And we appreciate everybody's participation. We know you have a really hard decision on your plate, and we appreciate the time you're going to put into this. We've heard a lot today in terms of things that may not have gone exactly right. But there was a 6-day hearing where evidence was admitted. There was a lot of time put into making sure there was a lot of evidence into the record. And I ask that even today, I've heard some things that are outside the record. And as the lawyer that is charged with zealously representing her clients, I'm here to say that I also have the obligation to zealously protect the process. And I think that the ALJs took the time that they needed to thoroughly examine the record, and they came out with the right decision. It may not be a decision that everybody loves, and it may have individual impacts that people don't prefer, but when you look at the route as a whole, then you see that they got the right answer. We went into the hearing ready to advocate for the best meets route. After those 6 days, we saw that 559 was incrementally better. So when we briefed, it was an easy brief because all we had to do was point out why 559 was incrementally better than the best meets. One of the key reasons for us is that there's 100 miles of that line where nobody has intervened. And it's not because of notice, it's because they didn't intervene. There's also a landowner who said, I will accept J2 because it protects a different link that affects a different part of his property. And I know that that's something that the commission gives weight to. And then, earlier you heard about individual impacts, like impacts to water. There's certain parts of Texas, and maybe it's all of Texas, of course, but certain parts where you really don't want to impact how people can get water. And so we heard that earlier today. And I know I just said it is a route analysis, and I believe that's exactly how the ALJs analyzed it and that they got it right. I would be remiss if I didn't say that my clients, too, are impacted in ways we've heard of today. I have a client who has a link, D6, that will go in his front yard of his house in a residential area. I have another client who has Comanche artifacts on their property. This would go through their property. And another one who is in partnership with the Texas Park and Wildlife on a wildlife management area, and this will bisect their ranch. So I think that if you look at it as a whole, route-wide analysis, as we're supposed to, the ALJ's got it right. Thank you for the time.
Thank you.
Please go ahead.
Good morning, Chairman, Commissioners. My name is Pat Long Weaver. I'm pleased to represent the Cowden Live Oak Ranch LP. It's a family limited partnership, and it's property that's been in the family for over 100 years. So I want to first address their individual link and then make some general comments and some suggestions. So with respect to their property, which is tract 1170, it's on link G21. All right. G21 is kind of a poster child for problems in these proceedings. It diagonally bisects a number of the properties. We've talked to a number of our other neighbors up and down. It impacts and impedes a very complex terracing project on the properties that's been put in place for years to prevent flooding. We're also worried because it's in a floodplain, it would cause problems to any structures. It also, our neighbor to the, immediately to the north, has been operating a family airport since that was fully activated in September of 2024, okay? One of the things we noticed and did point out, and the applicants did file an errata, was they noted that they had failed to detect that the G21 link would actually bisect one of the runways, not run adjacent, not be too close, it would bisect. So again, we just have concerns. Now, for my clients in this proceeding, both Best Meats did not impact G21, and neither did the ALJ's recommended Route 559. And we think either one of those is a correct result for the commission. But we just want to point out our concerns about routing in general, which I think need to be addressed, and how we do this moving forward. And as I always point out to my clients, just because G21's not on the table this second, it's still on the table until this process is through. I want to thank you again for giving this oral argument, and I appreciate your time.
Thank you.
Mr. Chairman and members, my name is Zach Brady. I am speaking for the Porter Family Land Company, LLC. Porter family owns property that would be affected by the construction of Link A3, which is the link that has drawn lots of opposition related to the Dinosaur Ranch State Park. We share those concerns. I will not restate them. The concerns specific to that area will be more eloquently and fully laid out by Mr. David Brown when he is up here for White Bluff Holdings, LLC. I will not restate what I anticipate those to be. I will simply say on behalf of the Porter family that we believe the ALJ's got it right and that we regret being in a position where we have to advocate for this line to be placed on any of our neighbors. It's the nature of the process. We don't relish that. With that, Mr. Chairman, that concludes my remarks on behalf of Porter Family Land, LLC. I'm also up on your screen for parties 3, 4, and 5. They're 200 miles away to the west. I'll stand down and come back, or I'll make those comments now.
Maybe for efficiency, why don't you go ahead, Mr. Brady?
May I respectfully request a fresh set of 3 minutes?
Yes, of course.
Thank you. Mr. Chairman and members, Zach Brady on behalf of Spades 5 LLC, Robert H. Chappell, and Frank H. Chappell IV, known collectively as Spade Ranch. The first speaker this morning, Mr. Ross, talked about the history of the Spade Ranch. He's right, and I'm honored to represent him. The Spade Ranch was the primary advocate in this case for the route selected by the ALJs, Route 559. That is a route that we teed up upon after having boots on the ground and looking at it. The key distinguishing advantage of Route 559, you've heard about the fact that it has no intervener opposition for 100 miles. That goes all the way back to this blue mark right here from west all the way east. This is Spade Ranch Exhibit 24, by the way. This, the blue box just to the west, is where the preferred route and 559 depart from one another. And 559 drops down to the south and runs through that 100 miles of no opposition. Now then, the ALJ said it better than I did, and I tried to. They said that that power line there would exist on the same vertical plane as the over 400 wind turbines on either side. That's the main advantage of 559 as compared to 552, is that it runs in and among wind farms on either side from a visual disturbance standpoint. I would argue that's why you didn't have a lot of intervener opposition there, because they've already got the wind turbines there. Oncor testified, this is in our exhibits, that the line was safely spaced and that they could operate it safely given the existing wind turbines. 559 is unique in all of these. I'm one of the few lawyers who's put together a route level case in all of these cases. 559 is unique in that when you look at compatible land use and paralleling, it outranks all the focus routes. When you look at HABs, it's tied for first in all the focus routes. And yet, it and 552 are still in the top quartile of cost, of lowest cost among all the filed routes. You get to check all 3 boxes: paralleling, HABs, cost with Route 559. That is a unique situation and one that I would encourage you to adopt the PFD because of that. Again, my clients don't relish having to recommend this go anywhere. They would be affected by over 15 miles. The point is that, as Mr. Ross said, L2 would decimate a vital water source. The route recommended by the staff would cross one spring-fed creek 8 times in 5 miles. Route 713 crosses a spring-fed creek that Oncor agreed was miraculous that it existed there, 8 times in 5 miles. You've heard a lot about length of land holding. One reason my clients have been able to maintain this ranch since 1880 is that they have a spring-fed creek. The only witness who recommended Route 713 or any other route using that horrible link L1 was staff witness Acosta, who testified that basically he reviewed subject lines, and that was it, of filings. Mr. Acosta also testified, this is really important, this is Exhibit 24 again, and I'm showing you the point between Glen Rose and Highway 183. Why have I folded it like that, Commissioners? Because Mr. Acosta could identify no feature of the study area to the west of Highway 183. Mr. Acosta had to have help finding Highway 183. There was a complete and total failure by the staff to analyze anything beyond the eastern 60 miles of this project, and the only thing he did there was look at the names of links in subject lines. So any argument for Route 713 today has to be heard with that in mind. He was the sole recommender of it until it hit the table, and the basis for his opinion was shown to be beyond flimsy. Thank you.
Thank you.
Next, Brad Bailiff for 2013 H2 Holdings Ltd. and Reese Jones Holdings, White Bluff Holdings LLC, and Bagley and Company Property. Mr. Bailiff.
Chairman, Commissioners, I'm Brad Bailiff. I represent Cook Canyon Ranch and H2 Holdings. 32 of the 130 filed routes cross my client's land, and every one of them cost more than the routes we support. Nearly every exception here is a route preference. It's not a misapplication of law, an unsupported finding, or a policy that should change. Those are the only grounds for changing the PFD. The ALJs recommended Route 559. If you prefer another route, the record points to Route 552. Neither is displaced by Route 713 on this record. Staff admits that Route 713 is not the cheapest and does not minimize habitable structures. It's about $67 million more than Route 559, $94 million more than Route 552, and 13 to 15 more homes. Staff asks you to pay more and burden more families. Then why 713? It avoids 3 links. Staff's witness explained his method. In discovery, the response was a cursory search on the interchange based on pleading titles alone. Staff's paralleling advantage depends on not counting a compatible link. Counted as the ALJs counted it, Route 559 builds the least new corridor of any focus route. Route 713 does not eliminate opposition, it moves it. Opposition runs along every focus route, though roughly 100 miles of Route 559 drew none. On the record, 713 is the most expensive focus route and affects the most homes. It also uses link B1, which you heard earlier runs within 500 feet of 2 Toller ISD school structures. Prudent avoidance requires a reasonable investment, and no one has shown that spending $67 million more to affect 13 more homes is reasonable. No exception explains why ratepayers should pay that premium. Route 552 costs less still. Every avoidable dollar lands on Texas families' electric bills. Adopt the PFD and approve 559 or alternately Route 552 and reject Route 713. One last request. Ordering paragraph 16 bars deviations beyond a minor one without amending the CCN. In practice, nothing gets adjusted for those landowners. Our replies propose language modeled on prior CREZ language, giving Oncor room to accommodate landowners with 4 guardrails: consent, no shifted burden, routing integrity, and no unreasonable cost or delay. Our proposal gives landowners relief without requiring new evidence, a route change, or a later deadline. Thank you.
Thank you.
Good morning, Chairman, Commissioners. I'm David Brown. I represent White Bluff Holdings They're located on link A3. Let me just say the bottom line of what I'm going to have to say today is that on the record presented, the PFD got it right. There are a lot of arguments, and I really am kind of changing some things up based upon some of the argument I've heard today. But and I hate to come across as Darth Vader here, but there are a lot of people who are going to be impacted by this line who don't want it. Everyone who gets it is not going to want it. And I certainly understand and appreciate all the concern everybody has for the effect on their own land. And certainly my client has the same attitude. But I am concerned that some of the sort of almost testimony today conflicts with the record. And I hate to pick anybody out, but White Horse in particular testified that this comes right over their school. Well, it doesn't. It comes through a hayfield about 800 feet from the school and about 800 feet from the house that was mentioned. If you stick with the record, as much as it's going to harm some people, it was the right decision. It's a difficult decision, but it's the right one. So there's absolutely no justification, as some parties have suggested, that this go on segment A3. Segment A3, which comes south out of the substation, goes past two sides of Dinosaur Valley State Park, right adjacent to it. It's clearly in the view shed. The evidence shows that. It will have a substantial impact on visitor experiences and everything else associated with that park. There's testimony from Somerville County Commissioners, from the mayor of Glen Rose about the impacts on those cities and counties as a result of anything that would take segment A3. You had literally more than 1,000 comments that were filed before the docket was even really commenced that said, please don't take A3 along Dinosaur Valley and then through the city and county. The opposition is substantial. If you want to talk about routes that affect endangered species, we're the only ones who presented evidence from multiple witnesses on the impact of link A3 on the golden cheek warbler. Actual occupied habitat observed just before the docket commenced. That's the only evidence in the record of that. The statutory requirements are that you look at, among other things, the historical, cultural, and environmental values that impact an area. Clearly, the Parks and Recreation values weigh in opposition to Dinosaur Valley. But again, you have John Graves' ranch that's directly impacted by this. Hardscrabble Ranch. You have airports, you have all these other environmental impacts that are associated with the park and with endangered species. We'd ask for you to just follow the record, and to the extent that you adopt a route in this case, you adopt 559.
Thank you. Mr. Bailiff, just real quickly, you mentioned the ordering paragraphs that were put into the CREZ dockets.
Yes.
Your recommendation mirrors that exactly or deviates from it?
It deviates from it in the extent that we added language that says that it will not be any closer to a habitable structure of an unconsenting homeowner. So it follows what was done in 38354 and 38379, but it adds the distinction that allows a requirement that it doesn't move it closer to another house without that person consenting to it.
Okay, thank you for that clarification.
Sure.
Thank you.
And that language is in our replies.
With that, I believe we've wrapped around to the beginning of the queue again. All names have been called, so I believe that concludes oral argument.
Got one, maybe two. Why don't you come up here just real quickly?
Please state your name for the court report.
My name is Garland Richards. I'm here. Thank you for allowing me to speak. Good morning, Chairman and Commissioners. My name is Garland Richards. I'm here today representing historic Fort Chadbourne, the Chadbourne Ranch, and 168-year-old Butterfield Trail. Oncor, when they ran the 3 routes through my ranch, did not even know where Fort Chadbourne was. They had misplaced this. They had designated Fort Chadbourne as being the town side of Fort Chadbourne instead of the historical Fort Chadbourne. We urge you to uphold the judge's decision, proposal for decision and approve Route 559 and reject the exceptions trying to bring alternative routes back to life. My situation in this case is very unique. We had Oncor put 3 of the major 6 routes coming from east to west in Texas across the middle of my ranch. The least destructive route coming across my ranch is Route 559. I believe I'm the only intervener who actually came to the table and offered to let Oncor cross my property. I was faced with 3 highly intrusive Oncor route options, and I chose to cooperate by accepting Route 559 as a manageable compromise. It crosses my ranch. Even Mr. Acosta, head engineer for the PUC, testified that 559 meets all the requirements needed to complete this line. But instead of respecting that cooperation, other groups are trying to push the lines deeper into our land using H22, I1, or J1. If you allow that, these massive towers will slice right through the heart of a 150-year-old, 9-generation working cattle and wildlife ranch. It will ruin vital pastures and destroy the views of historic Fort Chadbourne. Fort Chadbourne is 175 years old. It is a U.S. Army post used and is on the Texas Forts Trail. For decades, we have restored and maintained this national historic treasure entirely with private funds. Not 1 cent of for the restoration, stabilization, presentation of this has come out of a taxpayer's pocket. Route 559 strikes the right legal and moral balance. It respects a working cattle ranch and a wildlife ranch, protects a self-funded historical landowner who worked with the utility to try to get this accomplished. In the last 12,000 years, the most impactful thing that has ever happened to this piece of property has been this Oncor project. I suggest that you go down 559. Thank you for your attention to this matter and come visit a truly spectacular fort. I've only worked on this for about 50 years.
Thank you. We're going to look around just real quick, make sure no one else feels they were left off. Jaren come back up. Thank you, sir.
Thank you.
For the benefit of everyone in the room, I'm handing 2 rules and a law to the commission. Those rules are 2252, 25101, and HB 5066, just for ease of reference while we're in the room. Thank you. These cases are hard.
Jaren, if you just restate your name and who you represent.
My name is Jaren Taylor. I represent Oncor Electric, and I'll just start with the same line. These cases are hard. They're personal and they're human. They have acute individual impacts to the people's property that will be crossed. And the benefits, however, are felt statewide. Our notice rules notice the people who are negatively impacted by the transmission lines, not the thousands and thousands of people who benefit from the projects when they go into service. As I mentioned earlier this morning, on the other docket, we have rules that govern this process, and I want to talk about one of those rules. I want to talk about Rule 2252 in the notice rule, and I've just handed you guys each a copy of that. The PFD in this case makes a new finding that I've never seen in any CCN ruling, and it contorts one of these rules, and I want to talk about the words on the page. And we're going to go through this real quick. A1, this is where you get the notice requirements. It reads, an applicant must publish notice of the applicant's intent, and then I want to refer you down a little later. It also tells you when you must do this. No later than the first week after the application is filed with the commission. What you have to do and exactly when you have to do it. Scroll down on the page, number 2, 2252, number 2. The applicant must, comma, on the date it files the application, comma, mail notice of the application to municipalities, public officials. Again, it's prescriptive. It tells us exactly what to do and how to do it. Look at number 3. An applicant must, comma, on the date it files its application, comma, mail notice of the application. It tells us who, it tells us when, it tells us how. And then it goes through about 6 other things that have to be done with the notice. Again, it is prescriptive. Then look at number 4. The utility must hold at least one public meeting prior to filing. What's it missing? There's no comma at the date you file the application. It's permissive in its timing. You have to have one public meeting before you file your application. It's noticeably different than every other piece. This is also common sense when you think about what a public meeting is for. We hold public meetings so that we can garner feedback from the public. That is the point of these. In this case, we received a ton of public feedback. A lot of that public feedback was, hey, there's a bunch of transmission lines to the north of your study area. Please go and look at those areas. What would you have your utilities do with that feedback? Ignore it? Or would you have us go to work and to find additional quarters that we can provide for you all to make a decision on? That is what we did in this case. This is also common practice. If you go back and look, take a sampling of any 15 dockets at your commission, including the 2 you approved yesterday. All of those dockets you will find. After the public meeting, links were modified, links were added, ALJs found the notice sufficient, you found the notice sufficient, and PUC staff finds that notice sufficient. Chairman, if I can, I'll close with one other point. I handed you guys a copy of 5066. 5066 has gotten a ton of attention today. It's gotten a ton of attention in our legislative hearings. I want to refer you to the piece of this statute that is in the part that, well, let me just preface this a little. 39167 is the part that gets talked about the most. That is the Permian Basin Reliability Plan. It is in order for you to adopt it and push it forward. 39166 is the provision before that about what you have to do when you adopt these plans. Look at provision B. The commission shall develop a plan to implement each reliability plan, the Permian Basin Reliability Plan, adopted under subsection A. And here's the important part: to ensure timely development and approval of necessary transmission service improvements. This is not a study bill. It is a bill that demands action and very much tells us what to do. The words on the page matter. We thank you for your time.
Thank you. So that concludes all parties.
I believe so.
Thank you, Alex. All right, commissioners, and I know we heard from some the desire to, get resolution to this, and I completely understand that. I think it's appropriate for us to take time go back, the record was referenced multiple times here. Make sure that we go back and reconcile what we heard today with what's in the record, and be deliberative about the decision that we have to make on how to proceed in this case. So I would ask we give ourselves time to do that, bring this back to a future open meeting once all of us feel we've had appropriate time to digest everything that was said today and reconcile that with the evidentiary record. If that works.
I think that's good.
Okay.
Good path forward.
And I want to thank everybody for coming this morning. I know many of you traveled great distances multiple times to be here, to be at the Capitol and to engage in this. And it is not lost on us the amount of effort that has to be put in to meaningfully engage in this process. And so I want to thank everyone for that engagement. So we have one person still for public comment. Is that correct?
That's correct, Chairman, and so we'd like to recall item.
Yes, so we'll close those two dockets for this open meeting, and we'll move back to item number 1, public comment. Do you have the name of the individual?
Yes, Jennifer Derrick. If you're in the room, could you come up? As a reminder, public comment is for matters that are within the Commission's jurisdiction, except for matters related to pending contested cases, which are subject to the ex parte prohibition under Texas Government Code.
Good morning.
Hi, my name is Jennifer Derrick, and I am here on the wrong day. I'm not an attorney. I'm representing myself. This is not a line that goes through our property, but I appreciate you all listening to me, which is more than I can say for our elected officials on Wednesday. Chairman Gleeson, a few days ago, you said that land would be considered and that you all would mitigate the damage done to the land. And I'm wondering if after all of these hearings, you still feel that way.
So we're not here to answer questions, but I think I've been pretty consistent.
And you don't have to answer.
I want to say, I think I've been pretty consistent in saying that we, in all cases, we will order that impacts to land is mitigated as best possible.
And I actually didn't expect you to answer it, but it is something that I really want you to think about. And I was wondering if any of you all have visited any of these places that'll be affected. You're certainly welcome to come out anytime. I would welcome you to come see our property. I'm sure a lot of people here would welcome you to come see theirs. I wasn't able to attend the meeting last Wednesday, but I did watch the recording. And Commissioner Jackson, you asked somebody to please do their due diligence on the information that they received and who they received it from. And I asked the commission to do the same. And that's all I have to say today.
Thank you for being here.
Thanks.
All right, commissioners, that concludes everything I have in front of me on our agenda. Any thoughts, questions as we move forward?
No, just thank you for everyone that did show up. Like the chairman said, we understand you're taking time out of your schedule. It's important. It's important to us to hear you, so thank you for being here.
Yeah, I appreciate everyone who came today. I know many of you traveled long distances, and you really kind of shared what was in your heart. And I think, it's important, I think, to the commission, not only to hear from the utility, but also to hear from the landowners. And because you're boots on the ground, you're the people that are going to eventually have to work with the utility and get and do what we can do and what we need to do that's best. So thank you very much for coming.
All right, with there being no further business before us, this meeting of the Public Utility Commission of Texas is hereby adjourned.